is a value, is an important value. And for that, it must know everything which must come to the aid of the citizen to participate. So therefore, disclosure, information is integral to that expression dimension. The other value which the scheme seeks to promote is confidentiality of the contributors, and which is an enabling part of the scheme itself. So the enabling part of the scheme is confidentiality of the contributors. It doesn't make a difference between corporate contributors or any other contributors. The scheme treats all contributors equally. It doesn't pick and choose between contributors. So that value of the contributor's confidentiality, and the more important value with the learned solicitor pointed out, that moving away from a cash, black money, unknown sources scheme to a relatively regulated scheme, and which serves the public interest of taking a first or a second or a third, whatever step one may call, towards ensuring a greater credibility in the funding process. We look at the question whether a nexus, a quid pro quo will have an influence which is hostile or adverse to fundamental values of democracy is a different issue altogether. Because that issue, in my understanding, which may go into a political party funding equality of opportunity, or whether there should be no political party funding at all. These are larger debates. You want to look at what the Supreme Court has been grappling with this question. In Arizona case where the court says a matching contribution from public funds to publicly financed candidates. The court says that that places an undue burden on the freedom of expression. So all those things are in the larger political domain. Therefore, the equality of opportunity, free and fair elections linked to that equality of opportunity and level playing field, all those concerns, in my understanding, would require an analysis and evaluation which brings in norms and new norms for consideration and acceptance by the community and through parliamentary debates. Therefore, I don't think that aspect would probably be even invoked for the purpose of entering and looking at the three values which are in competition in this scheme. The public interest value, the confidentiality of the contributor's value, and the citizens need to know the information regarding who contributes to whom. Now, I ask myself a question. So how do you evaluate or balance these apparently competing, use the word apparently competing values? Yeah, I don't need to tell you lots about the three basic principles of proportionality, that there must be a legitimate purpose of a law, and it must have a rational connection with the object. And the next stage is that what the law does is must be to seek an object, must be least restrictive of all equally effective means. So the balancing test in this context would mean applying all this. And in a very fact-involved situation like this, it would mean a cost-benefit analysis, which would bring greater cost in terms of effectiveness, bringing in effectiveness, credibility, purity, and which would not do that, and what kind of benefits will flow from that. That kind of a cost-benefit analysis, not necessarily in the economic or the financial terms, but in an empirical terms. So in the empirical terms, I don't think that kind of an empirical analysis has been made available to the court, and that has not been the scope of discussion before the court. I'll just give an example, because this kind of a cost-benefit analysis which often comes in the proportionality domain. I'll give the reference to those cases. For instance, in Germany, we had in the province of Bavaria, crucifixion was permissible in public schools. So in a complaint given by those who did not believe that, the Constitutional Court of Germany said that there are two competing rights. The right of one set of people to say, I would not believe in this. The right of the majority of Bavarians who believed in display of crucifixion as a part of either a religious symbol or a cultural symbol. So there's balancing between two sets of freedoms. One a negative freedom, and another a positive freedom. This kind of balancing always comes in when we have very important social concerns in conflict. But some of those balancing can happen at a conceptual level. But very often, even at a conceptual level, it happens. Some right to the other yields to the other right. One right yields to the other right. So the yielding of it should take place under what criteria, what norms. That may differ from the right in question. When you're talking about this particular aspect of evaluation and the cost-benefit analysis of public funding or funding from any sources, public versus private, do we have all that kind of, I said, an empirical analysis under norms which can guide the court? We say this is how we apply this norm. We apply this norm and find this is faulty on that norm. On the other hand, if the court were to call upon to create a norm and say that any funding from any source, more particularly from a corporate source, intrinsically is an evil dimension to it, then the court is called upon to create a norm. That's why I said in the footnote that we are not entering into the domain, but even indirectly, if that idea influences the analysis of the court, there could be this problem. I think that idea has been brought in to probably color the debate, saying that this issue is intrinsically an evil matter, that therefore keep that in mind, therefore disclosure will be very, very important. So the nexus between that aspect and the disclosure sought is somehow sought to be very subtly brought in, and I say you'll also keep it in mind that subtle connection we have to probably sever, because we're only looking at the three competing values, diverse from all this, and see therefore is the court called upon to apply a proportionality test in this at all, if at all, then how would you go about doing that? I have my brief submissions. This is at volume 2. Like any reporting, the warrant reports, it says, the attorney says citizens do not have a right to know. So, I don't know where I said it in my submission. Let me read it out. Your Lordship, sir, could have volume 2.
Yes.
I'll quickly run through it, and then one of the aspects I wanted to probably also address that in the context of 19(1)(a) and the Association of Democratic Reforms and PUCL.
Volume
and
2 of,
Your Lordship, please.
Volume 2 is
Volume 2 is a separate volume.
Compilation of Union of India.
Convenience compilation also find it.
of the convenience compilation.
There's a convenience compilation.
Compilation of judgments and documents.
Volume 2 PDF 10.
Page
Volume
10.
2 PDF 10.
Lord Justice Kanas got it? I'll be in the course of reading submissions, making
Mr. Attorney, we have read the submissions. There's something that you want to highlight in particular in the submissions?
Yeah, as I read a few parts of the submissions, I thought in my notes I kept what probably I would be talking about.
Great.
You'll also kindly look at paragraph 5 of this submission, because the first 4 paragraphs like a kind of an introduction to. So we don't have to go into the larger question of how the emanation of political parties and how, as a 19(1)(c) associations, it comprehends a variety of aspects of political party, its supporters, its believers, ideology, and so on and so forth. Therefore, when a contribution to a political party comes in from either from a corporate or any other individual, it did not go under the color of a mere quid pro quo dimension. A person who supports a free market economy, and I find a free market economy which is propagated and supported by a political party, it will have my support. So beyond ideology, there are other considerations which bring about affinity between a contributor and the political party. So, and as I saw the tabular statement of all those contributors, it has all those small-scale industries, a wide range of small-scale industries. And we can't be fitted in to the quid pro quo dimension at all. That's why I said the scheme doesn't talk about a particular class of contributors. So these, I would probably be right in saying that the scheme is a regulatory within the broader concept of regulation, the Article 19(2). As while an argument has been raised that the right to know 19(1)(a) cannot be subjected to any restrictions under 19(2) as they stand, an argument has been stated in the written submission, though not has been explained as how it really can happen. So I proceed on the footing that, in principle, the concept of regulation can flow from any one of those 19(2) to 19(6). If one is right in saying that derivative rights or penumbral rights, the way of looking at a right can be seen beyond the text of the right, if that is possible, I suppose, implicitly, and if it's also correct in saying there can be no right without a restriction, and I'm sure no court will say that I will postulate a right, but I will not visualize the restriction of the right. If that is so, the regulatory scheme under 19(2) to 19(6) can contemplate such regulations as would advance the purpose of the scheme. That's what I tried to stay in paragraph 5. So we are talking about moving from an unregulated system to a regulated system. So when you move from an unregulated system to a regulated system, the lawmakers may look into various aspects of how that regulation can minimally be and what kind of regulation will achieve the object. As has been explained in the foreknown, the various aspects of regulations fall into one composite basic principle. If that basic principle is confidentiality, which radiates in different directions, I find that the challenge to what has been stated under 29(c) of the Representation of People Act or the enabling part under Section 31 of the RBI Act, they all get connected by one common thread. Why have we amended this law, that law? The common thread is confidentiality. And the enabling part flowed from Section 31 of the RBI Act. Once you enable, then how do you go about regulating? That thought process triggered which are those connected legislation which need to be addressed. Therefore, all those connected legislation which have a proximity to the question of moving from a unregulated to a regulated system, so they were addressed by the scheme and by the Finance Act, which looked at each one of the amendments. Therefore, I don't think one can say that I'll look at each one of the statutes in isolation and call them into question. So the approach that I'll look at the Representation of People Act, where the proviso says something, I look at it in isolation and says it's bad. I look at the Foreign Contribution Act and isolation, there is enabling foreign direct investment through a subsidiary company and so on, so is absurd, manifestly arbitrary. So this isolated understanding of each of the legislation, I think in my understanding is flawed, fundamentally flawed. Because I said the common thread is one important common thread about confidentiality. May I just quickly read a few more paragraphs in this, my written submissions. Paragraph 6. The scheme does not impinge upon any existing right, I put it like that, constitutional or otherwise, of any person and cannot be said to be repugnant to any right under Part 3 of the Constitution.
Yes.
A lot of Chief Justice raised a question yesterday. These are all statutory creations. A right came, a norm came, a disclosure came, it went away. What came by statute has gone away by statute. So if there is a restraint upon disclosure, it has been taken away by a statute. In that context, if all these, even a disclosure under the Section 182 of the Companies Act came by way of an amendment of the Companies Act, unless one is persuaded to say and one is also able to accept that proposition, that by reason of the statutory amendments, you acquired a right to have it retained as part of a constitutional scheme. And therefore, any change in this legislation for any purpose whatsoever, including a public interest purpose, an important regulatory purpose, regardless of all that, that will be put to test. I don't know whether it can be stretched to that extent. So the debate from 1958 onwards and the Companies Act, 69 one way, and then in 85 another way of looking at it, the debates in the parliament we wrote yesterday show a very multi kind of discussion which took place in the parliament. So I'm not sure whether anybody can come with the proposition that as a product of these statutory changes, certain inalienable, indestructible, inviolable rights occurred, and citizens have a right to ensure that they are not tinkered with. That amount to enhancing all these statutory changes, amendments, statutory creation to the level of a constitutional principle. If you may just read a couple of more paragraphs. Paragraph 7. Belongs to Kylie. The petitioners seek a declaration, though not the declaration is expressly sought in the petition. But I proceed on the putting, they want a declaration. The citizens have a right to know as an aspect or facet of the right to freedom of expression. Based on such a declaration, it is canvassed that the right to have access to the details of contributions the political parties must follow. Consequently, the confidentiality facilitated under the scheme is said to be impermissible. The above submissions are refuted on the following basis. Firstly, there can be no general right to know anything and everything without being subjected to reasonable restrictions. Secondly, the right to know as necessary for expression can be for specific ends or purposes and not otherwise. Arguments were raised yesterday about shell companies, and information was also showed to Lordships yesterday that the government has taken, I think, is continuously on the watch and vigil about shell companies. Two documents have been placed for the Lordship consideration. I don't think I need to take a Lordships into those, each one of those statutes and analyze them for the purpose of understanding what they propose to do and what they fail to do and all that. But in view of my larger submission that they're all connected by one common thread, namely confidentiality. Then finally come to paragraph 11. Again, it's a facet of my submission in paragraph 7. The judgments in so-and-so, so-and-so, where in the context of making informed choices about electoral candidates and knowing their antecedents, information limited to such knowledge serves a specific end of citizen choice of electing candidates free from blemish. Right to know for specific rightful expression was thus conceived. From that, it cannot be said the right to know for general or broad ends necessarily follows. Therefore, these judgments cannot be read to suggest that a citizen has a right to know that under Article 19(1)(a) regarding funding of a, has a right to information Article 19(1)(a) regarding funding of a political party. If there is no such right under Article 19(1)(a),
You have carefully gone through all your submissions.
Lordship, please, sir.
You have carefully gone through your written submissions. So if you want to just
No, as I read a couple of them, I want to make some explanations about it. So the further question of restrictions does not arise in 19.2. Kindly turn to the next paragraph. So why we talk about reading the PUCL and the Association of Democratic Reforms judgment in the way they ought to be read. The court proceeded on borrowing what Justice Douglas talked about, the penumbral rights under Griswold versus Connecticut. I suppose that the issue of penumbral rights and reading into 19(1)(a) in the context of general right to know about political funding may be misconceived. I just want to read a couple of paragraphs from Maneka Gandhi and this concept of peripheral rights and how we have looked at it. That judgment you'll also still find in volume 2, 2B.
Page.
Just open it right here. From here.
Graphs, we'll read them later, Mr. Attorney.
Yeah,
You can
that's
just
in
state the
volume
point.
2B,
2B. What paras would that be?
paragraphs 32 to 34.
We'll have a look at it because that
Yes.
discussion on penumbral rights, we'll look
Yeah,
at it.
Lordship, right. This first sentence in paragraph 33, which is it page 65 of this volume. just that one sentence. We cannot therefore accept the theory that a peripheral or concomitant right which facilitates the exercise of a named fundamental right or gives it meaning and substance or makes its exercise effective is itself a guaranteed right included with the named fundamental right. That's why I was.
But this logic
trying
has
to
also
point
now
out.
undergone a change after Puttaswamy, and Puttaswamy is 9 judges.
But
So there is no right to privacy. There is
in my
no right to
understanding-
privacy expressly recognized by the Constitution.
in,
But we read in that right in the right to life, liberty, dignity, the preambular values. So
those probably will stand on a broader conspectus. Therefore, the court will draw a classification among those rights where this kind of a broader reading to effectuate a constitutional purpose. They may stand on a different footing. Therefore, I do not know whether this statement of law is in direct conflict with Puttaswamy. It may not be. Yeah.
Mr. Attorney, we'll have a look at the
Yeah. May I just go
what else,
to-
Mr. Attorney, now in your submission? Any particular submission that we have missed?
Yeah, in paragraph 15.
That you have made a point that the scheme extends the benefit of confidentiality to the contributor.
Yeah,
The
the
Learned
second
Solicitor
part
has
of
also
the
elaborated
second
upon
part of the sentence. Therefore, I say this scheme does not fall foul of any existing right. So a constitutional court reviews state action only if it impinges upon existing rights and not because state action has not provided for a possible right or an expectation howsoever desirable. So even if you go to the extent of saying 1918 in the context of knowing this is desirable, you probably will not fault it on that ground. And that's what I repeated in paragraph 16. Yeah, just open this.
Your last point really in para 18 is that when the court proceeds to declare an aspect as part of a right, it will be in tune with separation of powers with the subject of reviewing or testing a law should be relegated to public and parliamentary debates. Declaring an aspect as a part of a declared right does not impinge on the separation of powers. For instance, we have said that sexual orientation is implicit in Article 15. That does not impinge on separation of powers. If the court were to lay down a legislative remedy, that impinges on the
That's why
separation
we're talking
of
about
powers.
laying down a norm.
But finding a
No.
right in a constitution, finding a right in the constitution.
No,
does not,
I don't.
For instance, we have said the right to education, even before it
didn't
became a part of
say that.
Part 3, we said the right to education is a part of
I didn't mean to say that.
21.
But when you lay down a norm which probably would require an analytical framework and weighing in fine scale the variety of concerns and interests.
No,
So
we
laying
have,
down
an,
a norm
we have an analytical framework.
beyond reading into a right.
No, we have a framework today. We are not creating a framework. We are testing the validity of the framework. That's
The
all.
framework available today is in the context of this scheme, this particular scheme. There is no framework with reference to which one can say the scheme is unconstitutional. The only fulcrum is 1918 that I have a right to know.
Right, thank you,
That's
Mr.
how it
Attorney.
is.
I think, Mr. Attorney, we've understood the submission. Should we close here? So that we'll give a little time to Mr. Amit Sharma.
I'll just take a few more minutes and
for
say
them and
that-
rejoinder.
I know, I understand. The rejoinder time is important. Just a few more propositions is how you test a law. Generally, these are well-known statements of law. Attempt was made to show that judgments which intended consequences. Consequences intended in 1955 express newspapers. That is. Let me quickly read these 2 or 3 statements about statements of law and how do you construe.
We've gone through your written submissions. If anything else to be added to those written submissions, I thought whatever you wanted to express yourself, you have expressed yourself.
I'll do that. Just by way of conclusion, much was said that the ruling party gets a disadvantage of this. That's not a consequence of the scheme of independence. Even if there's an unintended consequence, it is not an intended consequence. An unintended consequence, court will not strike down a law on the basis of something which happens.
That the solicitor already argued, merely
So
because the
unintended consequence is not
because
the
the
reason
provision
for
is
striking down the law.
capable of being.
I just want to give those two or
Issues.
3 judgments on that, right from Express newspapers,
In fact,
1954 onwards.
uh,
So what the law
Solicitor
does,
General has made it very clear that this has been true right from the beginning. So the effect thereof, we'll examine that.
that's good.
Thank you, Mr. Attorney. Thank you. Mr. Amit
Those
Sharma, would like
4 or 5 judgments, I'll put them along with a
just
note.
give us a
instead
separate
of,
note you can give us.
Yes.
Yes, Mr. Sharma. Mr. Sharma, how much have you collected by way of, you're not the State Bank of India, but in terms of the records which you have, what is the extent of the total quantum of electoral bonds which have been subscribed since the beginning?
That's in a sealed cover, my lord. So we have not opened that cover at all. Because that was directed, this honorable court had directed that to be in the sealed cover. And my lords, if my lord desires that sealed cover is there, my lords can have peruse it, my lords. But we've not opened it, my lords. We can.
Mr. Sharma,
Yes.
actually, the details of the bonds are available with you. Total quantum of bonds is available with you. Quantum of bonds given to the,
Yes, my lords.
that is there. So do we get any particular data? And is the data up to date? That is still, at least till March 23?
No, my lords, that's not there, my lords, with us. We have only till, in fact, there was a query by this honorable court, my lords. I went through the record, my lord. There was one order passed by this honorable court, which my lords had read 13 and 14 paragraph of 2019 judgment, my lords, separately. We took it as if it's to be read jointly, my lords.
No, it was very,
But my lords, I may just point out.
13 relates to data as of the date of the order. But you didn't freeze the data which you had to maintain as of the date of the order. You had to continue to collect the data.
Just, my lords, if my lords will kindly see.
Mr. Sharma, you should have asked for
Order passed in
clarification.
2021.
You never came back to us to ask us whether we want
May I just point
continuing
out-
data or frozen data as of the date of the
The
interim.
occasion could not arise, my lords, because of the order passed by this honorable court subsequently on 26th of March 2021, and my lords will find that in the, my lords, at page. Kindly, my lords, it's a EB final, my lords, which was filed by the petitioners, my lords. And that's at page 34, my lords. That was passed in one of the interlocutory applications filed by the petitioner, my lords.
Volume 3.
Page 505.
Which page? I will just tell. Milos, they have, I don't think that has been filed in the volumes, Milos, that's missing. But one of the initial volumes filed, Milos, that's called EV final, which I received through email, Milos, that was filed on 5/4/2023, Milos, by the petitioner. That's at page 34 of this, Milos. And my lords will kindly see this order and the relevant paragraph in this order, which my lords, I would like my lords to read is, that's right, that's right.
Volume 3, page 505. It is the court paper, volume 3, page 505, that order is.
Oh, thank you. And my lords will see, kindly see para 19, my lords. Of
Which
that.
order?
My lords, order dated 26th of March 2021. Which was filed, my lords, which was passed in interlocutory application number 183625 of 2019 in the present writ petition.
26th of March 2001.
21, my lords, 2021.
Is there at the volume which you had mentioned also? 50.
Volume 3505.
Yes.
And para 19 is at page 519, which he wants your lordships to read.
My lords, it took note of the entire earlier directions, my lords. This order takes note of the directions passed by this honorable court, pursuant to which the compliance done by the Election Commission of India, my lords, and then further, my lords, para 19. This was a second application which was preferred by the petitioner, my lords. The first one was rejected and thereafter the second application on the same ground, my lords. That's also discussed.
Where is the discussion with regard to paragraphs 13 and 14?
Lords, my lords will kindly see. Paragraph 12.
This was a application for stay, if I'm not
stay.
mistaken.
That's right.
Because a fresh window was opening up
That's right.
and Mr. Prashant Bhushan sought a stay at that
That's right.
stage.
That's right.
On collection of any further amounts
That's right.
and,
That's
you know, and the distribution of any further electoral bond.
That's right. Absolutely. And para 19 laws, it says that as far as the information to the Election Commission is concerned, the interim order passed by this court on 12/4/2019 takes care of the same. In the reply filed by Election Commission on 3/2/2020 to IA number so and so of 2019, it is stated by them that Election Commission of India has received seal covers from various political parties, national, state, and registered and unregistered parties in annexure C1 to the reply filed by so and Election Commission of India, provided the list of political parties who have filed necessary details as per the order dated 12/4/2019, the date on which Election Commission of India received. Milords, so Milords, perhaps Milords, this may be a reason, Milords, that, but we are Milords, we bow down, Milords. If there is any direction, we'll provide it, Milords. There's no difficulty on that.
Should have,
And Milords, the
you should
order,
have got
in
that
fact-
data. You should have got the data
Milords,
when
in
you are
fact-
coming to the court.
If I may say, Milords, if my lords will kindly also see para 13 and 14 once again, Milords, for.
Oh, please, Mr. Sharma, this is not what was, we read out that order that day, prima facie. All of us had expressed the view. And we expected you to come back with that data.
We can provide it during the, maybe in a short time, Milords, I'll instruct the commission, Milords, that.
And is the
By
data
Monday.
right up till 2023, March 23 now available?
Milords, we'll seek the data from all the political
Look.
parties, because Milords, it has to have a detail, Milords.
What's the time limit when the data is to be given every year?
Milords,
Every financial year it's to be given? What's the time limit for, what's the deadline
The
for that?
data is not to be given, Milods.
With regard to the
That
returns
is
file,
annual, yes, Milods.
when is that to be given?
Milods, before the financial year, Milods ends.
That means 2024,
That's right.
31st March 2024,
6 months before that.
6 months.
6
before-
months after the financial year, Milods.
So 6 months are over, September they got over, so you must have got the data.
It was not the data, Milods. That's what I'm trying to say.
Whatever the,
Only the quantum.
Up to 31st of March 22, you have any, 31st of March 23, you have the data.
Yeah, we have, Milods, but
You would have the data or ought to have the data.
It's only the total quantum, Milods, not the.
Right, you will have the total quantum,
Yes,
quantum of electoral bonds.
That will have, Milods.
And what is the bifurcation between different political parties?
Milods, that,
yes,
Has to
sir.
be,
has
because
to
it's
be.
we'll have to collate all with all the, yes, we'll
Because
have that.
parties have
All
to
the-
give
all
you
the- all
separate
the- all the-
contribution
All
reports.
the recognized political parties, Milods, and registered, whether registered or not, because we have.
So we'll have a look at your data. You can
Yes,
trace the
Mr.
data. Now tell us one thing. What was the basis on which the election commission had raised an objection to the scheme?
Milods,
Can you tell us what the nature of your objection
Yes,
was?
kindly see, Milods, there are two letters that we had written, Milods, to the Ministry of Law, Milods. Kindly see these letters. There are two letters which are dated 15th of March.
But I didn't deal with that submission, my lord. But I have the original file with me.
Yes.
RBI and EC, but after the correspondence, after their letters, there were meetings and meetings, and thereafter, my lord, a consensus decision was taken. There were meetings after the letters, my lord. If your lordship would like to peruse, I can show that file, my lord. Original file is here. But that's not an end of the matter. We thereafter discussed
That happened.
their concerns were taken care of. Their misgivings were, it was at the highest level, the meetings were attended by the governor and minister, etc.
Milods, that's come out in the rejoinder of the union also, Milods. That there were meetings which happened after the deliberation, Milods.
So what was your objection and to what extent was it assuaged?
One of the concern that we had, Milods, is that there are three categories, basically, Milods are aware. One is below 2000, the other is between 2 to 20, and the third is, Milods, I am not talking about the electoral bond for a moment, Milods. I'm talking about the general contributions which happen, Milods. So there are broadly three categories: below 2K, between 2 to 20, and above 20, Milods. Now, as far as, Milods, above 20 is concerned, it is to be done mandatorily by way of ECS, Milods, either demand draft check or ECS, Milods. So that's not an issue. We get the entire details. Milods, as far as these other previous two categories are concerned, Milods, less than 2000, Milods, it can be done in cash and there are no details about it. We are mostly concerned with the second category, Milods, that is between 2000 to 20,000. Now that there is no provision given either. It can be done by cash, it can be done by ECS, it can be done by check or draft, Milods.
No, but it was said that after amendment to 2017
Please.
under the Income Tax Act,
Please, Milods.
if it is between 2 and 20, then it will be treated as income, which is not allowable, which will be then taxable in the hands.
Please, Milods. So income tax has that, but vis-a-vis income tax, the RP Act, Milods, 29C, that amendment or that change,
You have not, under your rules, you have not made
No.
made a stipulation.
it has not happened.
It has not been stipulated that between 2 and 20, you please specify. And is there any also a rule with regard to multiple payments by the same person?
No, Milods. There is no rule as such.
There's no rule as
There is
such.
no rule. Any person says.
But do you have data with regard to 2 and above 2 and between 20?
Milods, we don't have a data. That's the difficulty because
You have data below 20.
above
Quantum,
20, of course, Milods, we have it.
above 20, you have the particulars. Below 20, it's just the lump sum amount.
Milods, we receive a contribution report, Milods, every year. Now, in that contribution report, we get the quantum as to how much in total a particular political party has received the amount above 20. Now, what?
And have you made any study or analysis of the data of dealing with the corporate bonds and how it's impacted the funding of political parties?
I'm not aware, Milods. I don't think, Milods, but I'll have to seek instructions. I don't think I'll have to seek instructions on that. I don't know whether there has been some ongoing study on that or not, Milods.
Now, volume 4, page 467 was your letter of 26th of May 2017.
Please, Milods.
In what manner were these concerns assuaged?
Milods, kindly, if my lords will see this 26th of May, Milods. The first is, Milods, about that section that I just spoke about, Milods, section 29C, that we wanted that same principle, same provision which is there in IT Act to be brought into 29C so that we also get to know, Milods. So that was one concern, Milods, which we had highlighted. And which is now, Milods, contribution about 2K is now included, should be included, Milods, in 29C. So that, Milods, there will be a proper quantification as to how much is in that bracket, how much is coming with a particular political party as a donation, which we don't which we don't have as of now. There is no breakup of that. We only get the total amount, that this is the amount which we have got in that particular category. So we have no data on that, Milods. And we don't know the source also. So whichever point.
Of
12th April 19, right?
12th April 19.
Volume 1, page 15. Volume 1, page 15. Oh, I don't know. Twelfth of April 19 order.
Yes, ma'am.
Volume 3.
Volume 5.
Please take the. You, as per you, you don't have data after 2019.
No, my lords, unfortunately, we don't
have
have it, my lord,
collected
but
the
I
data
put
with
down, if my
PF.
lord directs, then I'll instruct the my lords commission and we'll.
Our direction is already there.
My lords, but we can get the latest, my lords. Till the last window.
Till
23.
23.
Actually, the order which we. While the data as of
The latest, till
the
till
latest.
the last, yes.
as of 31st of March 2023 and submit it to us.
We'll do that, please. We'll do that.
And in fact, you can even give it to us, say up to the 30th of September if there's data.
Till the latest, because whatever we have, till the last that we
You
have.
won't be having, you'll have
We'll
to
have to
either.
require belows till the
one-
last that the
you-
political.
Either you
parties
get
have
it
done.
from the political
Please,
parties
Lord,
or you'll get it from the
State Bank of India.
Please.
State Bank of India.
Either of.
We'll not ask SBI to reveal the identities of the donors at this stage. That nobody is interested in at the present stage. But we would like the order we said, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the Election Commission of India in a seal cover detailed particulars of the donors as against each bond. The donors is also come in there. The amount of each such bond and the full particulars of the credit received against each such bond. So you give us the data that you have up to 30th of September.
That can be Milods, because the details of the donor, that's why in seal cover Milods. Otherwise, Milods, data can be, the quantum can be given.
Just show us what you have got up to now, up to 19. Keep it in the custody of the court. They have given separate seal covers for each political party separately.
Someone may have to collate it to assist your lordships from the registry or whichever my lord, authority.
So we are really dealing with a constitutional point. I mean,
Actually.
that this has no bearing on how we decide the constitutional issue.
No, this was really meant for, suppose a writ petition is allowed, it should not be then confronted with the situation.
Yeah.
That no details can be made available.
No, I was on a different point, my lord. This might possibly have everything received by everyone,
No, it's separately.
separate.
It's separate by each political party.
Then there is no collation also.
Collation is already done.
The order is to the political party.
No. The order is to both, everyone.
Both.
I don't
Yeah.
think political parties or party,
That's right, all of them, they have to, that's why they're
they
separate.
had to get it from the political, because they are the ones who are.
Yes, of course, of course.
So should we hear Mr. Sibal now, I think? That you want to add?
That's the only concern that we had, my lords. And this IT Act concern, we had raised it before the electoral bond in 2016 itself, which we have mentioned it in our counter affidavit, my lords. So that was the
Thank
DP of
No,
Yes,
your lordships, but I didn't address your lordships on how we addressed their concerns, etc. Would your lordship like to
Okay, tell them.
be assisted? Because it was more a consultative process with them. After having received.
you. Note of the fact that you had that you were consulted.
RBI and EC can't be taken lightly. madam.
You have does the EC also have any idea what was total expenditure incurred in the last election? No.
That we'll have. Total expenditure, yes, my lords, because there are three heads that we receive the accounts. One, as I said,
So, but, as far as political party expenditure is concerned, do you get data with regard to that also separately?
my lords, we get data of every candidate who has to file.
Candidate will not be sufficed because
My
the
lords,
political
as far as
party.
political parties are concerned, my lords, we don't get the expenditure of a political party in a particular election, how much they have spent. It is candidate
So
specific,
then your data is incomplete.
candidate specific, my lords, because that's.
It's
the-
not, you don't get the data with
No.
regard to
how
all
much
the
in
political.
total,
parties.
the political party spends, my lords, that may be,
No, that will be with the income tax department will be there.
Possibly, maybe, I'm not.
No, I'm asking him because he's the one who's.
no, that's right.
So, Mr. Prashant Bhushan, 15 minutes in rejoinder for you.
2 minutes.
fif-
You're not
Thomas?
going to give me just 20 minutes. I'll finish by 3:30.
But we'll have, now we have 50 minutes, so you, Mr. Sibal, Mr. Hansaria and.
Let's sit
and
for
Mr. Parasa.
15,
5 minutes, all right.
15 minutes extra if necessary. That's,
We'll wrap up today. then.
Only to
Yes.
answer your lordship's query, the political party's expenditure is a part of their annual accounts, which is filed with election.
Election committee.
I stand corrected, my lords. We have the,
thank you.
my lords, I stand corrected. We have the data of the political parties, my lords. We have the data. I stand corrected.
Yes, Mr. Bhushan, what do you have to say?
Yes. So the first argument of the solicitor was that because of these amendments, the volume of cash which is coming to political parties, which he says are maybe black money or is likely to be black money, that has gone down.
No, that's not his argument. He
That-
doesn't make a quantitative statement. His contention is that this was an effort which was made
Yeah.
to bring into the accountable channels
Yeah.
what was otherwise completely beyond the fold of accountability because the earlier schemes had not worked.
So let me just deal with that. Firstly, my lord, it did not close the cash channel. The amendment has left open the cash channels. The only change that has been made is that for getting income tax exemption, that 20,000 has been brought down to 2,000. That's all. Otherwise, donations up to, cash donations up to 20,000 can be given to political parties and they are not required to be reported. Quite apart from the fact that actually 20,000 or 2,000 does not make any practical difference because all that the political party declares is I have received X crores as cash donations, which are below 20,000. They used to say below 20,000 earlier. Now, if they want to avail of income tax exemption, they say it's below 2,000. So they say that we have received whatever, 100 crores, 500 crores by way of petty cash donations. Earlier, petty meant below 20,000. Now, petty means below 2,000 if you want to avail income tax exemption. Practically, it makes no difference in my respectful submission to the availability of cash to political parties or the ability of individuals to give cash to political parties. Practically, that 2,000, 20,000 makes no difference. Now,
That will not impinge upon the validity of the scheme.
yes, I know. Lord, they are saying that this whole exercise was to bring down the element of cash in the economy. They say cash is equivalent to black money. The object of the exercise was to make political funding of parties to come more through banking channels rather than cash. This, they say, was the stated purpose of this whole bringing in electoral bonds, one of the stated purposes.
Mr. Bhushan, there'll be slight difficulty. Even if it has not happened, probably the data may support you, the cash channel may not have come down.
No, cash did come down. I'm not saying cash didn't come down, but the reason why, it's important to understand why cash
Mr.
came
Bhushan,
down.
there are three, four arguments on which we want direct answers.
Yeah.
One is that the intention was to ensure that the money comes through regular banking channel.
Yeah.
There is a KYC required,
Yes,
which is not there as far as payment
cash,
cash is concerned. And also, even if it is coming through the bank accounts,
yes.
the KYC by the second KYC at the time when the bond is purchased is a second added advantage.
All right, let's assume that that's there.
Number three, their contention is that as far as payment is concerned, the person who's made the payment is concerned, the need to know the name of the donor has been protected. The confidentiality of the donor has been protected
Yes,
for 1, 2, 3, 4 reasons.
yes,
And therefore, when you are examining the reasons, you'll have to take into account what was the intent behind the
Yes,
enactment,
yes.
and not by a counter argument, which may be. And there has always been a conflict between confidentiality and declaration, or
So, my lord, in
both of them have their pluses and
Yes.
minuses.
to answer our argument that these changes defeat the citizens' right to know about who's funding the political parties because they introduce another anonymous source of funding. Now, the answer given by the solicitor to that is that, well, it had an objective. Now, these are two conflicting things. They say the objective was to limit black money or cash money coming to political parties or to reduce that. And therefore, we introduced these electoral bonds because many individuals or companies do not want to be known that they are the donors to these political parties because they fear victimization. So that was what the finance minister then stated. That's the argument also of the solicitor, that there was an objective behind this. Now, what I'm pointing out is that if the objective was to choke off cash donations have not been choked off.
But that was not the object at all.
Yeah.
The object, as the finance minister says in that article, and that's broadly an indication,
Yes.
was to add some element of transparency. That's what Mr. Jaitley said. That it will enhance transparency to a significant extent, and we would add two separate phrases which have been used. That's the point. You're right. In the earlier regime, absent this, it was purely cash based. You had those options, voluntary contributions, you had electoral trusts. But
Not just that, you had direct check donations, etc. That is,
a cash based scheme, an unaccounted scheme, proceeds on anonymity.
yes.
A according to you, they have continued anonymity.
Yes. They have
But,
continued that anonymity
but
of
there is,
cash.
but there is
as well
one
as-
change. But
Yes.
there is one change.
Yes.
That the electoral bonds have brought whatever is contributed to the electoral bond in the form of accounted transactions within the normal banking fund.
Now the question, so that's the second limb of the argument, that this reduces black money flowing into political parties because it's coming through banks. Ultimately,
Whether it reduces or not, to my mind, is irrelevant to the validity of the scheme.
all right.
The scheme may be wholly unsuccessful, but it may still be a constitutionally valid scheme.
No, Lord, then that is no response to my original submission, which is that it defeats a constitutional right of citizens to know who is funding these political parties. That's a fundamental right which your lordship has recognized under 19(1)(a). And and if what is being argued that the object of this bringing in electoral bonds was to reduce cash and reduce black money, so to say, and bring in only accounted money through banking channels to political parties, if that's the argument, then I'm just pointing out that that's not entirely correct for the reason. Firstly, you can still give cash. There is no bar today which has been placed on cash. The only change that has been made is
But
simultaneously.
how do you put a bar on cash?
Pardon?
It's a third economy. Much as you may impose a bar on cash, it's illegal. It's illegal, but you have a third economy.
That's the point, my lord, that it could easily have been done that all receipts of political parties, at least of political parties, will have to be accounted, whether it is cash or not. All cash also, any money being received, you could have done either of two things. One is to say cash is totally prohibited, you have to take through banking channels. This is one option. The other is, even if you take cash, irrespective of the amount, even if it is 100 rupees, 50 rupees, even the RBI, when it dealt with this electoral bonds, when it responded to electoral bonds, they said that if your object is to make political funding go through banking channels, there are existing instruments of checks, drafts, bank transfers, etc., which are available. Why are you introducing this anonymous instrument? This will allow, because as I pointed out, Lord, it's not that black money cannot come in through electoral bonds, though it will come in through banking channels. The example that I had given in my initial submissions was, suppose, as has been done, that you, by under invoicing, over invoicing, etc., you siphon out some funds, X crores or X thousand crores, to tax havens. From there, my lord, you have a company to which you have deposited. That's all black money. It's over invoicing, under invoicing money which has been siphoned out to those tax havens. You set up a subsidiary of that foreign tax haven company in India. It's a subsidiary under the FCRA changes. It was argued, my lord, FCRA is not in question here, but FCRA changes have been challenged in this very petition also, 2016, by which the availability of even subsidiaries of foreign companies to donate to political parties was brought in. And whether or not your lordship decides on the validity of that or not, your lordship have to keep in mind the fact that simultaneously that route was opened up. The route of subsidiaries of foreign companies donating to political parties was opened up. Now, what I am pointing out is black money can still flow through electoral bonds in this way. You have converted black money and deposited it into a tax haven bank account of some company registered in a tax haven. You then transfer that money to, you set up a subsidiary in India, transfer that money to a subsidiary in India. That subsidiary company, because you have removed the limit of 7.5% also, even if it's a shell company.
Mr.
That's-
Bhushan, at a constitutional level, this argument won't wash. I'll tell you why.
I am only responding to
No,
what
no,
was
that-
argued,
no,
my
that-
lord.
that's
I am
right.
not.
This will not wash. This-
of subsidiary company.
This will not wash at a constitutional level for the simple reason that the fact that they have been unable to, or they did not, dry all cash sources of funding of political parties is not an answer, is not there is not a ground to challenge the validity of a scheme.
I'm not using that ground. I am saying that the response of the government to my grounds. What were my grounds, my lord? My ground was Article 1918 defeats the rights of the citizens to know the funding of political parties. Number two, my lord, it promotes corruption because it effectively legalizes corruption because it allows any company to give anonymous kickbacks, legalized anonymous kickbacks to the parties in power. And I pointed out that the evidence, there is considerable evidence to show that almost all the electoral bonds have gone to ruling parties. Vast bulk to the ruling party in the center, the rest to the ruling parties in the states. And virtually all the electoral bonds that have been purchased are in 94.5% in denomination of 1 crore and the remaining in denomination of 10 lakhs, virtually nothing below that. Therefore, there is good reason to suspect. And I gave two examples also. I'm not saying that your lordship should use those examples because those parties, those companies are not before us. But I gave those two examples. One company has declared officially that they gave those electoral bonds to ward off excise issues which had arisen with the government. The other company who has purchased electoral bonds worth more than 450 crores from their accounts declared to SEBI has been the recipient of several mining contracts and various other favors.
You already argued, Mr. Bhushan.
But-
You're in rejoinder.
These are all auctions, no? Mining contract,
You're in the rejoinder now.
kickbacks, you
Anyway.
participate in all.
Don't re-argue your case.
I'm not re-arguing, I'm just pointing out that that's my argument. Now, what is the government's response to that? So how do they answer this question that this defeats the citizens' right to information? One answer that they have given, I was coming step by step. One answer that they had given was that there was a competing interest of bringing down cash or bringing down unaccounted money into the donations and finances of political parties. I am just answering that issue. The other argument that they have made is that there is a right to privacy. That's the argument made at the end. Firstly, my lord, the right to privacy doesn't extend to companies. It's an individual human right. Even in Puttaswamy, your lordship have laid down that that's an individual's human right. It's not a right of a company. So therefore, so far as those amendments which have been made to the Income Tax Act, to the Companies Act, etc., which anonymize donations by companies to political parties and remove the requirement of declaring who you have donated to or where you have spent this money, that right cannot be invoked for companies. The right of privacy cannot be invoked for companies. And even otherwise, my lord, if let's assume that there are some individuals who are giving this money, the question is, can those individuals claim a right to privacy which overrides the right to information of citizens? Even under the RTI Act, if your lordship recall, there is an exemption for privacy. There is an exemption for personal information. But that exemption stated that only that personal information which has no bearing on public affairs and which cannot be overridden by public interest is exempted. If there is a public interest override, even that information is not exempted. So in my respectful submission, my lord, that privacy argument cannot be used to say that my right to privacy about which political party I am donating to overrides the citizen's right to information, to know about who the political party is getting funded from. So that right, my lord, in a clearly would override, even if there is a right of privacy of an individual. Of course, companies don't have that right, but even if an individual has that right of privacy about donating what they have donated to political parties, in my respectful submission, that is overridden by the citizen's right to information. The other argument that was made was, again, on the basis of what the finance minister had said. It was argued that this is to prevent victimization. Now, firstly, as your lordship pointed out, the government would certainly know, or the party which runs the government can find out, look, this company had purchased electoral bonds worth 100 crores. We have not received anything from it. Therefore, obviously, they have given it to the opposition parties. And therefore, that much information which will still allow the government to victimize that company is always available with the government. Even if they do not use their control over the state bank to find out which company has given electoral bonds to which party. The argument that was made was that no, there is an elaborate system of protecting that information. It's very simple, my lord. Obviously, when a person purchases an electoral bond, he gives KYC, etc., the bank would have to record that this person or this company has purchased this electoral bond, and the number of the electoral bond would have to be recorded somewhere. Thereafter, my lord, when a party encashes that electoral bond, the party, the number of the electoral bond which that party has encashed would have to be recorded. Otherwise, my lord, it would make it open for counterfeiting. And therefore, you have to record these two informations. So therefore, it's not so difficult. If the government wants, State Bank of India would certainly know. And if the government exerts sufficient pressure on the State Bank, they can come to know. Even otherwise, my lord, the government would know as to which companies have purchased electoral bonds worth how much, and that we have not got it.
So one point is, of course, you've highlighted the citizen's right to know. What is the next?
Right to know that the sphere of the justification for victimization, etc., doesn't really apply. In fact, it's only the citizens who are being deprived of this information. Each political party would know, can know, and certainly the government can know. A citizen cannot, my lord, scan the.
Mr. Bhushan, I think point in rejoinder.
And then, my lord, just two more things. There was an interim order, as your lordship saw, asking the Election Commission. I am respectfully saying, because they are going to open electoral bonds window for this state assembly elections any day now. It can be opened tomorrow, it can be opened day after. And again, my lord, till today, till March 2022, electoral bonds that had been purchased were over 9,000, under 10,000 crores. Till today, I understand that the electoral bonds that have been purchased in this last 1.5 years has taken the total to 13,000 crores. Now, today, if they open the electoral bonds, again, in this assembly election, again electoral bonds will go. I am respectfully, my lord, requesting your lordship, even if your lordship does not stay the issue of electoral bonds after today, at least one thing your lordship should say, that it should be made clear to the parties who are purchasing electoral bonds that these may be subject to disclosure. Because This court has the power under the scheme also to seek information from the State Bank of India. And I am requesting, my lord, that at the end of this, if your lordships agree with us that this electoral bond is unconstitutional, etc., then your lordship should disclose as to which company has given to which party, etc. And even if that information has to be obtained from the State Bank of India. And that's why, my lord, I'm saying that at least today, because last time the same thing happened in that election commission appointment case. I had an interim application. I mentioned that interim application on Thursday on saying that there is one post vacant of the election commission. And the court is proposing.
Except for the difference, except for the fact that after the 12th of April 19 order,
Yes.
when you moved a fresh IA for stay,
That was for that particular.
that stay was declined by the then
Yes,
chief judge.
yes, that was at that stage
Mr.
for
Bhushan,
that particular.
That's why I asked,
bond.
what is exactly your prayer? You asking for quashing of the?
Of course,
entire-
I'm asking for caution.
Just 1 minute. You asking for quashing of the scheme, or you want that a disclosure should be made?
No,
of the
I'm asking for quashing of the scheme.
Okay,
of
therefore,
this
you had
anonymous
to
scheme.
answer that question.
And in case your lordships.
Mr. Bhushan, just one more question.
Yes.
The scheme has one advantage. There's a KYC at least. You will accept that there's an advantage in that.
No, that's all right. If the anonymity is removed, I have no problem.
So therefore, you argue on that.
I'm saying I'm challenging the scheme because of the anonymity. Remove the anonymity, I have no problem with electoral bonds. I'm challenging the anonymity of the electoral bond. So that is defeating the right to information of the citizens. So, so what I'm saying is,
So you are basically pressing for the entire scheme to be set aside, and you're also arguing that the amendment should therefore be
law that applies to a candidate doesn't apply to a political party. Why? What's the rationale? What's the basis, Malad, of coming to this conclusion? These electoral bonds are meant for a political party to be in power in perpetuity because the amount of money through these means, which quote unquote are legitimate, will empower that party through capital to influence everything. This is the most unconstitutional, undemocratic, unfair scheme Malad, that destroys the very basic structure of our constitution. Free and fair elections is the basic structure of our constitution. This scheme is neither free nor is it fair. It's not free because the industrialists cannot say no. It is not fair because in that process, the political party in power gets the maximum capital and the capital it wants, not for elections, for other purposes. That's very dangerous. Incentivizing, and I'm come to the other main argument. Incentivizing, I won't take more than a few minutes, Malad. I don't want to trouble your lordships. Incentivizing the use of banking channels. Of course, you will get this legitimate money through banking channels. In fact, that's the perfectly rational way of enriching yourself. Perfectly rational way. But that's not a justification for empowering yourself. I can understand if there was a correlation between this and the election process, in which you must disclose how much you have spent, where you have spent. But that cannot be because it is the candidate who is fighting the election, not the political party. As far as persecuting the person who has been given the money by that party to an opposite party, they will be persecuted. Well, why will they be persecuted? Well, let me tell your lordships, just to tell your lordships what the reality is. A big industrialist who has enormous power will give it to all political parties. And the party of the center will never hold it against that industrialist. Because everybody's benefited. The system enjoys this money. Enormous capital to the party that is in the center, and small little donations to the others. And everybody knows about it. It's not a secret. So there'll be no retributions that why did you give it to that party? Because you've also got the maximum. Why should there be a retribution? So this whole argument that no, there'll be a retribution, why have you given to that party? Supposing, Maharaj, I have got 100 crores. I get 100 crores, but the donation shows that he has given 500 crores. I'll know that 100 crores come to me, 400 crores have gone somewhere else. And if, Maharaj, for the 100 crores, the quid pro quo is 4, 5, 6 instances, Maharaj, then out of 400 crores, why should the retribution be more than just 4, 5, 6 instances? The same logic will apply. Same logic will apply. So why are you protecting those, Maharaj? And the most serious part, Maharaj, which I said earlier, that I will never be able to go to a court of law. What you're doing is giving a protection to corrupt transactions by not putting that information in the public domain, because I will never know. So, Maharaj, how do I move forward? Where do I go? I can't file an FIR because I don't know. I'll be subject to defamation. I can't go to court. I have under 156.3, I'll have to go to, I'll have to give some data. I don't have the data. So what court order are we talking about? Don't shield the process of corruption itself by allowing this to go on. If you want to deal with corruption, the first thing to do is to quash this scheme. This is the surest way for political perpetuity. Having said that, just 5 more minutes. Then, Maharaj, the respondents argue that PEBS is a matter of financial economic policy. It certainly is not. It deals with elections, nothing to do with financial policy. In fact, the EBS and amendments on which it is based changes the very ground rules of the electoral process. The very ground rules, which negates any presumption of constitutionality and on the contrary requires heightened judicial scrutiny. That's the answer to that question of financial and economic policy. Economic policy in the bearer bonds issue because that way you can bring black money into the economic system and pay tax on it. That's nothing to do with it. Two, he says, they argue that making the identity of donors an extension of secret ballot, the right to vote and donating of funds are distinct. The right to vote is secret ballot. Donation of funds cannot ever be secret. Three, he says, there is no uneven playing field. I will demonstrate it to yourself that the entire field is uneven. Four, they say the respondent has distinguished ADR and PUCL on the ground that the information sought for in those cases already existed and just needed to be disclosed. In this case, the only reason the information about the identity of donors is unknown in the present case is the structural design of the system. You have structured the scheme in such a way that it's unknown. So, I really don't want to say anything more. All I can say is, and what is the public interest that is being served here? I don't understand what the public interest is. Public interest not to know, not to disclose. And who are you protecting? For what purpose are you protecting these people? You are actually protecting yourself because you know who has donated. It is self-protection, self-preservation, self-perpetuity. How can the public interest in protecting the identity of donors outweigh the public interest in the public's right to know? To be free from corruption. So politics, as I said, it's impossible for us to get rid of free money, black money, no country in the world has got rid of it. Let's be clear on it. All your lordships can do is to tell the government, this is not the way forward. You want to deal with it in a way that is transparent, that gives us the confidence that it is not for you, it is for the larger public interest. Thank you very much.
Thank you, Mr. Siddharth.
That's also I would say I filed rejoinder submissions already to his submissions, A court master may just upload them. All that I have said to your lordships is dealt with that in what 12 pages. I'll give you a copy because I didn't want to take too much time to read them. There are others also. I'm deeply impressed.
Plus, the core of our challenge is to the
Yes, Mr. Siddharth.
to the statutory provisions which prevent public disclosure. Plus, those are the statutory amendments. The scheme follows based on those amendments, namely amendment to Section 29C of the Representations of People Act and Section 182 of the Companies Act. Those were the public disclosure provisions. The scheme, once the public disclosure comes in the scheme, there is no real scheme to survive. Now, this is to answer my Lord Justice Khanna's question, what are we challenging? We are challenging those two statutory provisions because once that goes, the scheme itself collapses. The basis of the scheme is non-public disclosure. Because with that, I would submit why do we need in rejoinder 2 points only? Why do we need public disclosure? Because number one, as the US Supreme Court said in Buckley versus Valeo, a political party may represent anything to the electorate. It may self-ascribe any label to itself to the electorate. But one of the best ways of determining what the party is about is where or who it is going to be most responsive to is where it gets its funds from. If that aspect itself is removed from the public domain, so a party can say X, take the money from Y or other interests, and the public has no way of knowing. So public information is necessary for voter to form its view into voting. That is a substantive right to vote, is an informed right to vote. And therefore that information as to who has given you money to, so that the voter can match what you are saying. Are you taking money? Are you a green party? You're claiming to be a green party, but taking money from oil interests? There are n number of examples. So that is one interest which is necessary. Second, Manoj, the question fell from the court yesterday to the government that how will you prevent quid pro quo? Plus, quid pro quo has been used by both sides very broadly. Let me just try and bifurcate it. Plus, one would be policy influence or policy capture. Strictly not corruption. Second will be legislative influence or legislative capture. Strictly not corruption either. Plus, the final stage would be corruption or bribery. Plus, in my respectful submission, the only constitutional safeguard against preventing quid pro quo is, in fact, public disclosure. And one constitutional court in South Africa, I just want to place 2 paras. In Rejoinder, normally I wouldn't place paras of a judgment. Only 2 paras because exact same situation arose in South Africa. And the Constitutional Court of South Africa has said that the only way to ensure that these other things, nothing can be removed in a polity, is a complex space. Surely we can't expect a perfect world. But from areas or zones of influence to movement to zone of corruption, that can be prevented by public disclosure. Your Lordships will just have page 6654. 6654, volume 4. Volume 5, I'm sorry, my apologies. Plus, the case is titled, quite aptly, My Vote Counts versus Minister of Justice. And straight away, para 40 at page 6653.
What page does this case begin? 66?
Well, 6653 is the relevant portion. Bookmark number 60.
Yes. This is volume 4 of?
Volume 5, my lords. Volume 5. Plus para 40. As the court has it. The reality is that private funders do not thoughtlessly throw their resources around. They do so for a reason and quite strategically. Some pour in their resources because the policies of a particular party or independent candidate resonate with their world outlook or ideology. Others do so hoping to influence the policy direction of those they support to advance personal or sectional interests. Money is the tool they use to secure the special favors or selfishly manipulate those who are required to serve and treat all citizens equally. Unchecked or secret private funding from all, including other nations, could undermine the fulfillment of constitutional obligations by political parties or independent candidates so funded, and by extension, our nation's rightful place. Then thereafter, our freely elected representatives must thus be so free that they would be able to focus and deliver to their core constitutional mandate. They cannot help build a free society if they are themselves not free of hidden potential bondage or captivation. Now, para 42 is important. I'll read only from the 3rd line. Only when there is a risk of being exposed for receiving funding from dubious characters or entities that could influence them negatively for the advancement of personal or sectoral interests would all political parties and independent candidates be constrained to steer clear of such funders and be free to honor their declared priorities and constitutional obligation. And that risk would enable by a regime that compels the disclosure of information on the private funding of political players. So, my respectful submission is public disclosure is the real check. Public disclosure is the real check. And therefore, from all the kind of things which happen in politics, from that to moving into the zone of corruption. And in a democracy, it's the public which tests the party every day. Plus, effectively, that is the biggest check. Plus, finally, an argument on confidentiality was made. A certain formulation of that was made on privacy. Plus, and a comparison was made to right to vote is a secret right to vote. And therefore, this by extension you should have a secret right to fund. In effect, if I understood, my lord, that was the formulation. My lord, our respectful submission is right to vote is your own exercise of franchise. It's the least level of participation as a political actor in a democracy. The minute your levels of participation starts increasing, if I want to fund and influence the system as a whole, of course I cannot be claiming privacy or confidentiality. If I'm holding a public office, my level of confidentiality or privacy will be restricted to my family zone. So, Malas, this privacy, even in respect, of course, corporations don't have a right to privacy. It's Article 21 right, flows from right to life. So that is out. But Malas, even assuming natural persons who may be donating, their right to privacy can certainly, or right to confidentiality, whichever way we frame it, cannot extend to an area where they will now impact the entire political system and seek to do so secretly as a matter of right. Of course, it cannot be. So, as we go up the system, in terms of our political influence, the proportionality doctrine will ensure that your ability to assert confidentiality or privacy as a right is reduced. Finally, I'll just conclude by one quote. Thomas Jefferson and my learned friend Mr. Bhatia says that the best protection against victimization is full transparency. So that, just want to emphasize that. And finally, I would just like to end with a quote by Thomas Jefferson. He said, information is the currency of democracy. And someone added to that quote saying its non-disclosure should always be suspect. I'm grateful, Manoj.
Thank you. Yes, Mr.
Lordship, I apologize for being on VC, Lordship.
Really don't give rejoinders, but I have no objection.
As an intervener, not technically right, but let me not have something to add, my lord.
Lordship, I just wish to take 5 minutes for one of the petitioners.
Let Mr. Khansare conclude. Yes, Mr.
Please,
Khansare.
Just a minute. Yes. My lord, the two quotes which my learned friend, Mr. Solicitor, started saying, practicality requires that I contribute to political parties. Practicality requires, these are from the quotation because now we have the advantage of YouTube and the transcript. Require I contribute with a degree of confidentiality so that I'm not victimized in future. Lord, this is the whole basis, my lord, of the scheme. Lord, my submission is, my lord, we are talking of political parties. We are not talking of rival groups who are collecting money. And the political parties fight election on the basis of their development activities, maybe on freebies, maybe on caste census, but not that we will victimize a political person, a person who does not pay us, at least who's paying someone else more. The whole foundation is, there is a confidentiality, otherwise there will be victimization. With great amount of respect, my lord, nobody is coming forward to say, my lord, the rival group will be victimized. The government is trying to justify it, my lord, with this contribution, with confidentiality. And the other justification is, my lord, my learned friend has some difficulty in using the opaqueness or, my lord, the anonymity. He said confidentiality. Very well, my lord. Confidentiality of 100 or 1,000 corporate houses, would it not override the right of information of 140 people of this country, my lord?
That is already argued.
No, my lord, what they said, my lord, yes, the confidentiality is the key, is the required. Confidentiality of 100 or 1,000 corporate houses is required. But, my lord, my submission is right of the citizens would override, my lord, overweigh the right of the donors. How can you say, my lord, the 140 crores people's right, I will not take into account. I'll take into account the right of the 1,000, my lord, or 100, my lord, or 5,000 corporate houses. Thirdly, my lord, the black money Mr. Sibbal has given, I will give in a chart, my lord, of the RBI guide, my lord, from the RBI source. The amount of money was, my lord, in 18 lakh crore cash in 17-18 when the scheme was introduced, and today 22-23 it is 33 lakh crores. My lord, the details are given with the page numbers in a tabulated form in a chart to the court master. My lord, lordship would, my lord, just take into account, if your lordship to take that, my lord, the black money has not gone or cash money has not gone. Fourth, my lord, my learned friend Mr. Mehta said that what will happen is pre-2017 era. And he gave the figures from 2004 to 2014-15, where, my lord, he did not name, the BJP got 65% from undisclosed source. Presently also, my chart at page 59 says in my written submission, 65% is from undisclosed source, presented by them. The same amount of undisclosed source remains, my lord, even with this scheme. And finally, my lord, as a citizen, I must say, my lord, that my learned friend Mr. Mehta said this was the best solution we found. As a citizen, my lord, the best solution would be no cash donation. My learned friend says digitization has gone in our country 9 times more than Europe and US together, 5 times more than China. Let there be no digital, no cash transactions, my lord. It will stop. Everybody would know it.
Thank you, Mr.
I'm
Pasha.
extremely grateful to your lordship, lord, and it's
Yes,
very
Mr.
difficult for
Pasha.
me, lord, after 4
The last word for you, Mr. Pasha.
Thank you, Lordship. Lordship, I apologize first for not being present in person. It was because of an injury. Otherwise, I would have been there before my lords in person. Lordship, just two very short points. With respect to funding through subsidiaries by foreign companies, Lordship, there has been an attempt to misconstrue the scope of my lord's order segregating issues. Now, the order that had been passed by my lords, in which these issues had been segregated, my lords had said that the Finance Act 2016 and the Finance Act 2018 and the amendments it brought about to the FCRA will be placed before a separate bench. Lordship, now what was amended in 2016 and 2018 Finance Acts in the FCRA was the definition of foreign source to exclude from a foreign source those companies which had foreign investment. However, Lordship, I wish to point out that where we are, minus the electoral bond scheme, even assuming those two amendments to the Finance Act stand, is that each foreign source, whether there are four major sources through which foreign investment comes into the country, Lordship. One is foreign direct investment, one is foreign venture capital investment, one is foreign institutional investment, and one is external commercial borrowing. Each one of these lordships, and I have placed the regulatory guidelines and the regulatory mechanism for each of these in volume 4 along with my written submissions. So the FEMA external commercial borrowing 2000 regulation 2018, the SEBI FVCI regulations, the SEBI FII regulations, and the SEBI non-debt instrument regulations, all of which lordship cover ECB, which is external commercial borrowing, FII, foreign institutional investors, FVCI, foreign venture capital investors, and FDI, which is foreign direct investment. Lordship, for each of these, and I could point out the page numbers of the regulatory mechanisms and the schemes and the regulators who are appointed, but very broadly, Lordship, for FIIs, there is a complete disclosure required for the end use of the funds that come in, including which company they're investing in. That has to be placed before SEBI and the stock exchanges. Same for FVCI, foreign venture capital investors, which is also SEBI regulations, where SEBI is the regulator, and the regulatory mechanism requires a full disclosure of where the funds are being placed. For external commercial borrowing, Lordship, RBI is the regulator, and the external commercial borrowing regulations require.
We needn't go into this. Thank you.
No, Lordship, I just finished my sentence, Lordship.
Keep them
Only
with us.
one line, my lords.
Lordship, if it's not for the bond scheme,
Only one line, my lord, if your lordship permits.
Lordship, I'll just finish one line, Lordship, and I'm done with my submissions. If not for Lordship, if not for the
We would
electoral
like
bond,
Election Commission to get the data in accordance with the order dated 12th of April 2019 for the period ending 30th of September 2023. On 12th, ऐसा लिख लीजिए.
Only one line.
We have heard arguments on behalf of the contesting parties. Stop. Arguments are concluded and the judgment is reserved. Next, on 12 April 2019, an interim direction was issued by this court to the Election Commission of India. Full stop. The Election Commission has produced in a sealed packet, it's data pertinent data as of the data in terms of the interim order as of April 2019. Full stop. The order of this court was not restricted to the date on which it was pronounced. Full stop. If there was any ambiguity, it was necessary for the Election Commission to seek a clarification from this court. Full stop. In any event, we now direct that the Election Commission shall produce up-to-date data until 30 September 2023 in terms of the interim directions which were issued on 12 April 2019. Full stop. This exercise shall be concluded, shall be carried out within a period of 2 weeks on or before Karlo. The data in a sealed packet shall be handed over to the Registrar Judicial of this court.
Not only one line.
Lordship, may I conclude that thought and Lordship will
I
then
think
see if
I'll
it's
be feeling
relevant or
in my
not
duty if I don't say this. But I was little perturbed when Mr. Sibal said that there is no possibility of eradication of black money in this country. I am not that pessimistic. But the way in which digitized payment is increased, it is significant improvement and the country should not be pessimistic. We are in the process and we will eradicate black money.
Thank you, Mr.
Lordship, may I conclude
Thanks
just a
to all
thought
the
in one
current
sentence?
councillors.
Lordship?
Thank you very much. Thank you very much.
Lord,
for
one
the-
more
Yes.
suggestion, my Lord. It's my suggestion. But despite, my Lord, my saying about SPI, etc., if your Lordship's conscience, my Lord, desires to be satisfied more, your Lordships may consider RBI, which is a statutory bankers bank. There may be some administrative issues instead of SBI because they may or may not have presence all over, my Lord. This is just to show my bona fides. That's
Please, Your Lordship.